Let's go.
Well, good evening, everyone. It is Monday, December 8th. Welcome to Behind Enemy Lines, Volume 3, the last one of the calendar year. Kostas, how you doing, man?
Good, man. It's good to talk to you again. Good to be on.
Good to take a happy holidays. Are you guys a happy holidays, Merry Christmas, festive Kwanzaa, happy Festivus family? What's the correct nomenclature there at Casa de Moros?
To quote a funny comedian I heard on TikTok the other day, what we say is to not offend anyone. May the birth of our Lord and the one true God, Jesus Christ, bring peace to your household, to the belittlement of all other false religion. No, I'm kidding.
No, I mean, we could possibly go wrong with that one. That's an excellent one. Can you send that to me later?
Say Merry Christmas, but if you want to say Happy Holidays, I'm not going to bite your head off. That's fine.
Yeah, I know. Well, when you walk around the courtroom, the courthouses, everything's you don't dare throw out a Merry, especially when you practice in like King County, Washington. You don't throw out a Merry Christmas in the courtroom. It's always Happy Holidays, Your Honor. So
Ninth Circuit already hates us, so we just go for it.
Well, we got a lot to talk about, and then we got a really cool special guest joining us in a little bit. But it was orders list today, and I was originally going to do something really stupid and do a live thing at 6:30 in the morning, and then I kind of realized like it was probably going to turn out to be a big nothing burger because it looked like the cases that had already been granted on Friday.
Yeah.
And but I did want to talk to you about a few things that did or did not happen today. There were two magazine ban cases. Of course, the one you're most intimately familiar with and emotionally attached to, Duncan v. Bonta, and then the case out of here in Washington State, Gators. It looks like they just got punted to this Friday. Is that right?
Yeah, they relisted them for this Friday, on which there's already a bunch of other Second Amendment cases pending. So I don't know if they're going to actually decide anything this Friday or if they're just lining them up to punt them again, because as we know from Snope last year, although Snope got denied, it got relisted over a dozen times before getting denied.
Yeah,
so
that was a brutal journey. Brutal journey. Yeah. Okay. And then the first of three assault weapon ban cases also was on conference last Friday. That's the Viramontes case out of Cook County, Illinois. That appears to have also been relisted for this Friday.
Yeah, that's a SAF case. It's a final judgment case, but it's against Cook County's particular ban. And also relisted for this Friday. So.
Okay, and then we got two other, you guys got one out of Connecticut, and NAGR has one out of Connecticut where petitions are in, and I think response briefs are due actually in the next few days. That's the Ravella case and the Grant, NAGR case, right?
Yeah, and I forget if they filed waivers to the response in that one. If they haven't, I wouldn't be surprised if they don't respond, and then the Supreme Court orders them to, because that's been the pattern lately. So
it has been the pattern. In fact, we're going to talk about that pattern also. All right. Then also, and this is a thing that I want people to kind of understand is how does the Supreme Court clear its docket? Because there's a lot of ways that the Supreme Court can clear its docket. This week, on Friday, last week, I should say, there was 18 separate challenges to 18 United States Code Section 922 G1, felons with firearms and all of that stuff. The conference the Friday before had about like 24 or 26 of those cases. And so far, 2 of them have been denied. The rest of them have either been relisted or there's no action taken yet. I want you to explain to everyone how a lot of these cases could end up log jamming up and then end up with the great GVR once we get a ruling on of a different case.
Sure. So I heard somewhere, by the way, that 5 more were denied today, but the rest are relisted. I would need to confirm that.
Did a word search on some of it, but you literally have to go in and like
there's so many. Yeah,
I know there's so many of them. Yes.
Yeah. But to answer your question, GVR stands for grant, vacate, and remand, and what that usually means most of the time is they decided a case that's at least somewhat related, and so instead of actually doing the work and deciding a case, God forbid, the Supreme Court instead grants it, sends it, vacates the decision below, and remands it back to the court to basically do it again with this new ruling in mind. Sometimes that's easy because they decided a case directly on point. For example, let's say they held Duncan and took another magazine case, decided the magazine issue, and then GVR Duncan. Then it's very clear, Ninth Circuit, do a different ruling because this one isn't in line. But other times what we get is like the Rahimi GVRs, where it's not really—
or the Bruin GVRs.
Or the Bruin GVRs. At least Bruin changed the standard, though. With Rahimi—
It changed the standard, but it didn't change a lot of rulings.
Exactly, because these courts don't operate— what the Supreme Court needs to understand, and maybe they do and they just don't care, but a lot of these courts don't operate in good faith. So
really
simple as like, oh, just do it again. So all we got with Rahimi was, and Bruin for that matter, was they redressed it in the Rahimi costume and sent the exact same ruling out, the exact same result. So the Supreme Court just ultimately needs to just decide specific discrete issues, not—
They do.
Right. Yeah.
But what they're going to do is, and again, we'd love to have 8, 9 different Second Amendment cases before the United States Supreme Court, but let's be realistic. We got 2, and we're going to be lucky to get a 3rd. Mm-hmm. And so if they can clear some of these issues, or at least delay having to deal with it. And so what I think what you and I are both reading in the tea leaves here is that Hamani, and at least in some ways, is going to address who can be disarmed and things such as that.
And in fact, this prediction could end up being wrong, but the fact that they seem to be preparing a lot of these 922G cases for a Hamani GVR might hint that they don't intend to go narrow on Hamani. They might go broad, because otherwise, maybe they will go narrow.
That's a good point. I hadn't thought of that.
Yeah, I could be wrong. They could go narrow and GVR it anyways, just to punt and buy time.
Yeah, that would be a complete punt, though.
Yeah. So that could happen, but I suspect if they really are going to hold a lot of these 922G cases for Hamani, maybe they are going to say some broad stuff. Maybe they're tired of dealing with all these petitions, and they're like, we're going to lay out a rule here on how disarmament works.
Well, they're going to have to do something about it, because there literally is, I'm not joking, there's like 45, 55 of these things kicking around on petition right now.
And there's always dozens more coming. So this is not going to stop. There's always going to be, it could be that the rights restoration rule the federal government is working on will reduce it to some degree, but that's not going to answer all questions. There's still going to be, other stuff that they aren't willing to restore rights on, that's going to be an open question. So
let me ask you this question, because we see with all these 922 G1 cases how they could be GVR'd after Hamani. And then we got that Schoenthal case that's kind of kicking around that could be GVR'd, as could any other sensitive place case after Wolford, right?
Yeah.
What could possibly, though, be in? Why could the magazine bans or the assault weapon ban cases be held? Because there's nothing that would GVR those back right now.
Yeah, I'm not going to say they won't GVR it for Hamani or Wolford, because you never know. But I suspect what's happening right now, if I had to guess, is that even the Supreme Court doesn't know what it wants to do with Duncan yet. I think they kind of want the 3rd and 7th Circuit cases. If I'm being optimistic, maybe they are bothered by the fact that if they deny Duncan, it will affect so many people in California with the Freedom Week magazines. So,
you think?
Our petition straight up said, just if you don't want to grant it, just hold this case until you get one, even across terms. Just hold on to it. Don't give it back until you decide.
Hang on to it.
Yeah.
Hang on to it.
Maybe they'll do that. I don't think they've decided what they want to do. I don't know if they have 5 votes. I hope they do, but it could be, maybe Barrett and Roberts are being cagey, so without more information, we can only speculate, but I don't see this being— I think we're either going to get a grant, a denial, or an indefinite hold, like we suggested. I don't think they're going to GVR these for Wolford or Hamani. I think that—
No, I don't think so either. And for all the people who are always chiming in, especially on X, well, how about a per curiam? Come on.
Look, I think a per curiam would be called for, but I don't think they're going to do it on such a hot issue.
I agree with that wholeheartedly.
Yeah.
A per curiam would be appropriate, but it would be just a nuke bomb. It'd just be a nuclear thing for them to do.
That would be such a hilarious anti-climax.
It would be, though.
It would destroy
my God.
and all these other states. Like just a one-page ruling. Like, your rulings are dumb.
Yeah. Oh, God. If only, right? Okay, but you know what case did get accepted? Hey, and I'm only bringing this up. We're not going to get into this, but there was a case of Trump v. Barbera, however it's pronounced. This is a reanalysis of the 14th Amendment's application to birthright citizenship. Now, I'm not going to get into that issue. We're going to talk about what we normally talk about. But you got into an exchange a professional exchange. I want everyone to, it's not like Kostas out there throwing Donnybrooks out there on X, but it was about originalism. Okay, about originalism. And I want you, because I thought the way you explained it out there was really good, and I think it's something that people should understand. So can you explain to the viewer, when we talk about originalism in statutory or constitutional interpretation, what are we talking about?
So I think part of the problem is that we've given it this name originalism, and it makes it sound like it's an ism, it's a theory, when really all it's saying is that, hey, the Constitution and the amendments should mean what the people understood them to mean when they adopted them, the original public meaning. That's not a controversial thing to say. That's what the people agreed to. And if you want to change it, there's a way. There's an amendment process. You have to build a consensus enough to get 2/3 support, whatever it is. But if you can get that consensus, then you can amend the Constitution to change it. But the problem with these other methods, like interpretivism and whatever, or they or living constitution or whatever these are, is that they're fundamentally wanting judges to reinterpret what the people agree to. It's like, so then each judge or the Supreme Court is basically running a constitutional convention and, you know, changing its meaning, because if a provision of the Constitution can mean something different 100 years later or 200 years later, then that means it doesn't really mean anything at all. It means you can just change it by saying, oh, this is what we think it means today. No, it means what it meant. And look, there's going to, as I said in the post, there's going to be disagreements. The birthright citizenship debate is a great example of this.
It's a fact.
There are good faith people on both sides. The majority thinks the 14th Amendment does confer birthright citizenship, but there is a minority that, contrary to the majority's claims, does make some good points. And even in the case Wong King Mark that everyone's talking about, there were two dissenting Supreme Court justices that disagreed. So, and it's fine to have that debate, but the debate should at least try to incorporate the history and the meaning, not just what we want something to mean.
Well, and you know, I did a video about the case, more just to kind of break it down, and it really comes down to just the analysis of about 6 words inside the 14th Amendment, as far as whether or not they're subject to the jurisdiction thereof. And when you take a look at why the 14th Amendment was drafted and who it was intended to protect, it was absolutely done for all the right reasons at the exact right time that it needed to be done, perfectly done. But now how the 14th Amendment is being used is completely opposite. And when we get back to what did those that ratified it mean by birthright citizenship, they were talking about people who had either been brought here against their will, or there were descendants of those that were brought here against their will, versus now what you have is a situation where people come here unlawfully and then their offspring claim birthright citizenship. So that's what it's a fascinating argument.
And it could go both ways, by the way. Like it could very well be that, and not, again, we're not to drift too much into a topic where neither of us are experts on, but but it could very well be that maybe this wasn't what they intended, but it is what it says, you know.
That's a good argument. I mean, if you're going to go as a textualist approach, it's like, well, that's kind of what it says, just right there in black and white.
The answer then would be not complain about the ramifications, but amend the Constitution.
You know? That's right. That we have an amendment process for that as well. It goes
both ways. It's not just it favors conservatives. It might be against the general conservative viewpoint. And our solution is, if you got to build a consensus to change the Constitution. That's your solution, you know.
And it could theoretically be done.
Yeah.
Okay. So here's the other thing I wanted to talk to you about. There was in between our last Behind Enemy Lines and this one, we had all the amicus brief come in on Wolford v. Lopez, including, and I think this is a big deal, and I want you to kind of speak to it. We had an amicus brief filed by the United States Department of Justice. So kind of explain to the viewer, you know, again, we're trying to, the way I see it is we're gonna call balls and strikes when it comes to DOJ here. So when they do something good, I think we should talk about it. If they do something that makes us scratch our heads, we're gonna have to talk about that too. But talk about this to the viewers.
Sure. So the United States Department of Justice did what I later found out. I had to correct myself. It's not
right. I know.
Amicus brief in favor of the Second Amendment. My bad, everyone who
I said it too. I said it also.
Yeah. And the reason that was mistaken was apparently they did one in this case that got mooted out. And that's why I don't remember it. It was a New York City case in 2020 that they granted cert to, but then New York repealed the law. And apparently the Trump administration did do an amicus brief at the time. I just forgot about it or never read it. But I will say that their petition in support of certiorari earlier this year was the first time that's ever happened. So so they still should get their flowers for that. But the brief was excellent. And I would say that it is a little more general than you might expect from like a brief from like SAF, for example. And I think that's because they are still the government and they don't want to say anything, that might hurt them in the cases they do want to defend. So they went for these broader principles. For example, they argue, well, if something totally destroys the right to carry, then that means it's unconstitutional. I would agree, but we could also go further than that. And to be fair, they didn't suggest that if you need that to break the Constitution, but they only went so far in their arguments. But it was a very well written brief, and I think it bodes well for us in the Supreme Court. And further, they're actually getting 10 minutes of argument time as well. So. Should be good to see.
Now let's talk. Tell the viewers about that. So the United States Department of Justice, because that case is set, I think, on January 20th for orals, right? So the United States Department of Justice is going to take 10 minutes of oral argument time from the petitioners on that.
Yes, and I'm working with Alan Beck to help him prepare for oral argument. He's all too happy to give him that 10 minutes.
He's all right. So essentially SAF. That's because this is an SAF case, right?
No, it isn't.
It's not. No.
Wilford is not. We did May v. Bonta, but I am helping organize moot courts for Mr. Beck. But but we did an amicus brief in his support as well.
So petitioner's counsel is essentially, so people understand, is acquiescing 10 minutes of his time. It's not like DOJ gets an extra 10 minutes lopped on. This is the Supreme Court. They run everything on a tight clock around there.
They do, but that said, don't be surprised if the DOJ is up there for a lot more than 10 minutes, because the Supreme Court has also been known when they are interested in, when it's a fun case, like a Second Amendment case, they will sometimes run over the clock and give them more time. Okay. So we'll see if that happens here. But yeah,
good to know. Good to know. I want to talk about, because you guys did an amicus brief in Wolford, and you're the author, so these are your words. But trust me when I say this, because I pulled it straight out of the brief. As the court has confirmed, the historical records support relatively few places where carry could be prohibited, but the three examples it provided were legislative assemblies, polling places, and courthouses. And so it would appear that you acknowledge that there was historical analogs to support disarmament in certain places, but it was extremely limited. And then we're going to talk a little bit more, because you guys really developed out a theory both on the how and the why. So why don't you explain where, because I thought you guys did a really fantastic brief. And this is what I like about good amicus briefs. And again, I agree with you on DOJ. It was more symbolic than it was like, wow, I hadn't thought of that, right? The amicus briefs is where you get these really cool little angles, and you guys took a good one. So I want you to kind of walk the viewer through, and I got a couple of other slides that we could share with them, but kind of walk them through where SAF came with a pretty unique argument here.
Sure. So historically sensitive places, the ones that the Supreme Court has confirmed, were places where the deliberative business of government was conducted. So it would be like your polling places, courthouses, and legislative chambers. And the fear there wasn't that, it wasn't like somebody was going to mug a senator in the Senate. They weren't talking about routine crime or, crowded places or, spontaneous violence. What they were worried about clearly was impassioned people. So even people who are otherwise law-abiding, in the midst of a fiery debate, could come to blows, could pull out a sword or a gun or whatever else. And so that's the historical tradition of, not being armed around the king's men, as it were, going back to the England. So that's where we came up with, and this is a theory I developed before SAF. I was in May v. Bonta, we argued the same. The Ninth Circuit never addressed it, annoyingly, but maybe now the Supreme Court will. And from that tradition, by the way, there's also a practice you saw frequently in these historical places of providing for an armed person, a police officer, other security to be there. And that's where you also get this accompanying characteristic of these places were often secured, not always, but often. And perhaps that suggests that the government can also restrict carry if it's going to comprehensively secure a place, be it like an
Right.
airport sterile area, for example.
Right here. If the government could be permitted to disarm its citizens anywhere, it can only be in a location where it takes steps to ensure it is providing for their protection. So if a place is so historically sensitive, then it would be a place that government would prepare for.
Yeah, and that's what's so silly about what California, New York, and others have done in Hawaii. It's because they call all these places sensitive, but do nothing to protect them. If they're so sensitive, why isn't the government protecting them? You know, the truth is the security test, and there is a counter argument to the security test, which is, well, do we really want the government to be able to call a place sensitive just because they put security guards there?
Right, because it creates the police state, and they just put them everywhere, and now everywhere's a gun-free zone, and you got armed government officers everywhere.
I understand that, and maybe there will be room for challenges if they tried something like that. However, practical reality is they can't put security everywhere, and at least the security requirement makes the government show that it actually believes a place is sensitive and not just over designating it.
Very difficult until funding of police departments becomes the in thing to do politically again too, rather than the opposite.
Yeah,
of
maybe
what
they'll put drones
everywhere.
I don't know.
Oh man, oh god, don't get us anymore. Okay, a couple more cases, and then we're going to get over to our guest here. But okay, Schoenthal v. Raoul. This is Illinois' public transportation carry ban. A horrible ruling out of the Seventh Circuit. Now, both of the respondents here have asked to waive a response brief, not particularly uncommon. Agreed?
Yeah, it's very common to waive a response.
Okay. What do you think? Do you think the court's going to make them respond on this?
Very likely. If they don't, it probably means it gets denied. However, there could be an exception in this one, which is that maybe the court's already decided they're going to remand it for Wolford, you know, in which case maybe.
Well, and that was going to be my next question. Yeah, could it also be that, hey, it doesn't really matter because we know we're just going to kick it? Because it's a pretty, pardon my language, it's a shitty ruling. I mean, not because we lost. I mean, that's all we talk about at Washington Gun Law is all the crappy rulings that we lost. But sometimes it's how you lost it and why you lost it. You're like, oh my God. And if that rule of law were to perpetuate amongst the other divisions, holy God, you know, it's what could they possibly do in the way of disarming based upon places?
Yeah, I mean, the ruling said you can ban carry anywhere that's crowded or where children are present, and children are present everywhere, and lots of places get crowded. The whole point of the right to carry is you need to defend yourself. And where are you going to need to defend yourself? Not in the middle of the woods, typically. I mean, maybe from wild animals, but it's when you're somewhere that has people. You know? So.
That's right. And how they define crowded, what constitutes crowded. I mean, it's the
very
possibilities are endless. Okay, now listen. Before we talk about this next case, sometimes on the channel, when I'm about to do something that's really infuriating, I will warn people, hey, this might be a 3 fingers of bourbon, a breathing exercise, or a barf bag. Now, I really don't think you should be chucking back bourbon during the show, but maybe later. So if you got to do a couple breathing exercises or grab a barf bag, but we got to talk about this. Rhode v. Bonta. They got accepted for en banc review.
Yeah, so the Ninth Circuit is proving that they just have no shame at all. None at all. They don't care about their own reputation. They know. I'm serious. I don't care. You know, we did an amicus brief. I don't know if they've even read it, but we did an amicus brief in Yucataki that basically emphasized, hey, there's been 9 of these that you've granted en banc to. No other right can claim this. Other than Nguyen, every single Second Amendment win gets reversed. Like, this is a little ridiculous, don't you think? You're destroying the esteem of your court. And what do? They grant Rhode, which involves a background check that denies 10% of people who try to use it. Incorrect.
A background check for ammunition, by the way, not for firearms. Yeah, let's get that out there too.
It denied in one 6-month period, it denied over 50,000 people incorrectly and caught like a couple hundred actual prohibited people. So if this were the right to vote or any other right, there's no way they would stand for this. We're going to do an amicus brief, of course. I don't know at this point what's left to say. Like, I'll just, you know, I almost want to just.
I want you to know that in my little note scripts here, I literally was like, I just wrote Rhode v. Bonta, and then I was like, get out of the way and let him go, because I knew.
It's just so frustrating because it seems like we're just not allowed to win. I think I said this in my Yucataki brief. If this were a situation where, like, we would win some, we would lose some, we would be bummed out, we lost some, but they gave us like, okay, but no, we just always lose. And
Always.
and they always reverse even panel victories. It's not like our arguments are meritless, because these panels, these 3-judge panels sometimes give us wins, and they always get reversed. It's ridiculous.
Well, sometimes you've gotten 3-judge panel wins after wins at the trial court too. So you go into the en banc 2-0 looking pretty good, right?
And this comes after, by the way, one of the points our amicus brief and Yukitaki made was also, you don't do en bancs when we lose. Like we asked in Wolford and May v. Bonta, we asked them, hey, this vampire rule, you relied on a black code. Are you sure you don't want to take another look at that? And over 8 dissents, they said, nope. And now the Supreme Court granted cert. And I thought maybe, just maybe, that would give them a little pause. Like, oh, we better calm down here because the Supreme Court's paying attention. No, they are just shameless political hacks. That's it. They are political operators. They should run for Congress. Why are they in the court? Like, if you have no shame about this, if you're just going to destroy your esteem as a court, I probably shouldn't be saying this as a lawyer. And now, by the way,
I want you to know that I am enjoying every freaking moment of this. So you keep going.
Changed the rules. So it used to be, if you got the consent of the parties, you just get to do an amicus brief. As of December 1st, they changed the rules. Now I need to do a motion for leave to file an amicus brief. Only for en banc, by the way. They only changed this rule for en banc. So I'm wondering, maybe I'm paranoid, but I'm wondering if they're going to...
Or maybe you're just relying on history of the Ninth Circuit, but what are you paranoid about?
I mean, we'll see what happens, but if they deny us leave to file our amicus brief, then I know they were kind of mad about that Yukitaki brief, I guess. We'll see what happens. But seriously, it's very disappointing. At some point, right?
You get jerked around. It's like business relationships, right? You get these they jerk you around. You just deal with it, right? And then eventually, one of those days, you're like, you know what? F you. This is bullshit. And you just got to have those moments. And I think you kind of had that in the UK.
I think what's happening.
I think you just had that a few moments ago too. And I think hopefully it was therapeutic for you.
I mean, I think what's happening, even their colleagues have called them out repeatedly on the Ninth Circuit. So I don't think they care. I think what they're figuring is the Supreme Court isn't going to possibly reverse all of these. So if they reverse a couple, oh well, but we're going to keep ruling for California and try and uphold as many of these gun control laws as we can.
Well, yeah, it's like those late stages when you get to the upper levels of missile command.
Yeah.
Right? I mean, you can only save so many of the cities. There's so many incoming at this point.
Yeah.
The Supreme Court can only shield so much.
Yeah.
Well, hey, thank you for that. You want to take a couple breaths?
No, I'm all right. I can go for another 20 minutes if you want to.
I bet you can. Maybe we'll do that one of these days. Kostas on the Ninth Circuit. I'll just introduce you, and I'll go out and grab a sandwich and all that. Come back about an hour later. It's like, hey, Kostas, thank you very much. Appreciate it. All right, listen, let's get our guest on here, okay? Hey, listen, he's a former ex-prosecutor, now running one of Wisconsin's largest defense firms. He's a former instructor, competitive shooter, a relentless 2A advocate. He's got a YouTube channel called Attorney Tom Grieve. He was the breakout creator in the 2024 Gundies event too, and one of the best hairdos in the business. Good friend of mine, Tom Grieve. Tom, thanks for joining us.
Thanks, guys. Great seeing you, Bill. Costas, great seeing you again.
Good to see you, Tom.
Thanks for being here, man. How is everything going? Holiday season out there in Wisconsin? How things going?
I gotta say, after watching you two Ninth Circuit boys go back and forth, I feel great. I could do this every day. This is like an adrenaline shot, a serotonin hit. This is like, who needs drugs when I could just listen to you guys just go and say, you know what? Seventh Circuit, not so great, but it's not those guys. So
it could give, my dad, when he was around when I was a kid, he always used to say, Billy, I just want you to know one thing. Anytime you think you got it bad, you don't have to look too far to find someone who's got it worse for you. And yeah, well, there's a lesson in that right there, Tom.
Yeah, the internet brings us together. But no, how are you guys doing?
Good, man.
We're doing good. I will tell you that I really enjoyed that last 5 minutes from Kostas, though. That was the best 5 minutes he's put.
Yeah. I literally awesome. Looked for popcorn. I'm not exaggerating. I turned to my left without thinking about it and was disappointed. But yeah.
I hope you guys are both willing to speak for me at my disbarment hearings at the Ninth Circuit.
I will. Yeah. Well, I will be like, listen, it'd been one thing if he would have got up there and told a bunch of lies, but everything the dude said was true. So, I mean, how do you get disbarred for speaking the truth, right?
And I'm just going to give you my 2 minutes to do whatever you want with it. That's my gift.
All right. Well, hey, Tom, I got a couple things I want to talk to you about. The first thing I want to talk to you about is this SIG P320 thing. And when I say the SIG P320 thing, I do mean the SIG P320 thing, because, and you and I have talked privately about this, that we were a little disappointed with members of our larger community, some of which immediately went to burn SIG to the ground. Others went immediately to, there ain't anything wrong with this. And I think that you and I kind of took a similar approach of, I'm just going to kind of try to figure out what the hell's going on here. And you got a chance to sit down and talk to a plaintiff's attorney who I think had a bunch of lawsuits kicking around against SIG. So why don't you tell us a little bit about that experience first, and how you guys connected and what you learned through that process?
Well, let's start with how I connected. I looked him up and I called him, and he answered because he thought I was going to refer a case to him. And I didn't say that. But about 20 minutes into me asking him questions, he asked, I think I just took this call because I thought you were going to refer a case over. I'm like, nope, next question. So look, he was very cordial with me. It got less cordial as it moved along, but he was still cordial.
When he realized he wasn't going to make any money off of you.
He suddenly had a meeting in 2 minutes, but that's okay. Look, I think has sued SIG over 100 times all across the country. Like, this is not a guy, this is like the guy who's suing SIG. And I was really curious to hear, like, he's won, I think, his last 4 trials, something like that. Like, it's that guy. And I was really curious.
He's trying these cases and winning these cases in court.
Yeah, that's right.
Okay.
That's right. I think he's
legit.
won. I know I will get fact checked by the internet, but I think he's won the last 4, maybe 5.
Okay, trial. But the bottom line is he is actually going into court, litigating these things and winning them.
Yes, not your typical plaintiff's attorney. Yeah.
Okay, that's legit.
No, he's doing it. He's doing it. So how is he doing it? Because we all know what the internet got really pissed off about, right? The internet got pissed off because there's someone holsters it, or it's in a holster and it just goes up, right? So that was kind of my first line of questions was, look, what's your theory of the case? Like, in other words, in layman's terms, as we all know, but like, what's the deal, right? What's the
deal? Right.
And I asked, are you saying that they go off kind of by themselves or what? And he said, well, look, at the end of the day, the central issue is this. The SIG 320 trigger is reasonably unique insofar as it goes off with only 17/100ths of an inch of a trigger pull, which is the shortest that you have for something that is basically entirely pre-cocked with no external safeties. And we're talking external safeties, we're talking both active safeties, like something you switch on or off, as well as passive safeties, of course, like the trigger shoe. Yep. So we're talking everything there. And in essence, basically his argument was, look, the trigger pull is so short, so light, and there's no safeties of any kind to stop this. This is negligence through and through. I mean, in a nutshell, that's what he was saying.
Okay. Now, you are really familiar with firearms yourself. I don't know whether you have a P320 or not. I don't care. I'm not going to ask you anyways. But how plausible did that theory appear to you as he explained it to you?
So I'm
not assessing the lawyer. I'm assessing the theory here, right?
Yeah. No, I gotcha.
Yeah.
I remember reading an old study. I want to say it was done by the FBI. I'm sure it was many years ago because I think, as you know, Bill, I read a lot of old stuff. I came across this study, and this is just what this whole case reminded me of. And it's so intuitive, like it's just kind of baked into gun culture at this point. And it goes something like this. Well, they found out that it is equally safe to have a short, heavy trigger or to have a long, light trigger. But what the FBI came out and said is you can't have a short, light trigger. Now, of course, that's what the whole premise of the 1911 platform is, but there's also an active safety and maybe a passive one built in if you've got, like, the grip, right? So I think the thrust to it is, and I'm going to answer your question, but the thrust to it makes a lot of sense to me, which is they are punishing a company that is doing something novel, and we know plaintiffs' attorneys just love that, right? Anything
Right.
goes wrong, and if someone innovates and breaks from the pack, boom, they're going for you because it's easy to make the case. No one else has done this. You're doing this. And we see something bad happen. Obviously, you get this whole res ipsa loquitur. Well, yeah, the thing speaks for itself. It's the innovation that did it. So, look, we've all seen the videos. I've seen the videos. I know you guys have seen the videos.
Yeah.
I'm inclined to believe that there's something going on here. Now, uh, look, firearms malfunction from every manufacturer. Like, we all know this, right? I mean, no one turns
Right.
out something that's perfect. But there's not a lot of safeties going on here, and I do have concerns about that if I were SIG.
Okay.
I have a question,
Okay.
and
Yeah.
before I ask my question, I do want to say SAF in the past has been SIG was a donor to SAF, so I want that disclosed. I don't want
I like
anyone
SIG, just to be clear.
huh?
I like SIG,
Oh
just to be
yeah, and
clear.
I own two P320s because of that light trigger. It hides my habit of pulling shots low to the right. Anyway, I'm left-handed, so but my
I was
question
going to
is,
say, are you left-handed shooter?
yeah, I am. I'm
Oh, all
left-handed and
right.
everything, but
Okay.
so my question is that I think you were kind of alluding to it, which is that these videos we've seen that are very troubling is these guns seem to go off by themselves, but that's not really what the lawsuits that are winning are saying. They're
Right.
actually saying, well, the trigger is too light and it doesn't have an active safety, which by the way, the California versions do, but regardless, so it doesn't have a manual safety and it's too light. That's not the same thing. That would be like if, it's too light and you fidget with it and it goes off, but they're not actually demonstrating from what I've seen an ability to replicate these guns going off in holsters. So it seems like he just went and found, maybe someone has, I'm not that close to the issue, but it seems like this lawyer has gone and found an alternative theory, which doesn't really explain the unintended discharges, which are in holsters, because nobody's messing with that light trigger. It's just in the holster. And that's a little troubling to me. It's like, why are these cases winning if he seems to be going after some entirely different issue?
So there's an interesting piece of sizzle here, and then I'm going to get to something you brought up, which is a great point. The sizzle piece is this: we all love being able to say "gotcha" on corporate America, right? And the sizzle piece here is that it came out when I was doing lots of research on what went down in these trials, who testified at what, and I found that at one of the trials, one of the early designers for SIG testified about the fact that the trigger shoe originally had one of those passive safeties in it, just like a Glock, right? So it can't just be pulled by itself. You actually have to, stick your finger in and do something with it, right? And according to that person, they went ahead and tested the safety on it without it. So in other words, the way it came to market, right? So the trigger shoe without that passive safety, and they found that it was fine. So they decided to roll with it. Now, I'm sure the implication about why they reduced it was cost savings, and I can imagine that roiling up juries if you're able to kind of insinuate it without saying it, I'm sure. And there was supposed to be a plan. It sounds like that already happened for California, but there was supposed to be a plan, according to testimony and other evidence that I saw, that there was going to be a trigger shoe with one of those passive safeties coming out. So there's going to be an OEM version of that, but it never arrived. So I think that there's a lot of, as I know Bill's a extremely accomplished trial attorney, and I'm sure he and I can relate on the fact that it's great if you've got some sizzle to throw on that steak.
Oh, yeah.
And I think that's part of the sizzle here. Now, the other thing you brought up that was really good was whether or not anyone basically tested the nature of will these guns just spontaneously go off. If you remember, I think it was, I don't know, 15 or so years ago, there were problems with Remington 700s that were spontaneously going off, and people were photographing like them kind of just sitting there and someone just like touching the bump stock and boom, it goes off, right? Pretty difficult to dispute that. Here, what one, I don't remember if it was a company, or I think this may have been the Michigan police working with the FBI. That may have been what this was, if memory serves. If you remember that report that dropped 6 months or something back, what they did was they milled out the side of the slide on a SIG 320, and then they wanted to see if it would go off by itself, and they subjected it to all these different tests. and there was a certain failure rate with it. So they presented SIG with this information, i.e., your gun goes off by itself, SIG. SIG came back and he said, whoa, 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 whoa. What firearm is designed to have part of the slide milled away so you can observe the firing pin and all these other sort of interactions? That's part of what holds it in place and prevents the very issue that you observed. Do it again, but test it without doing that. And if memory serves, they went ahead and they did that, and there wasn't anything to report. So,
Yeah.
but again, that was going back to what Bill led with, was the sizzle, the clicks, all that kind of stuff. When that study dropped, oh man, boy, that just took over GunTube for like 48 hours,
And
right?
people are misleading. And I'm
Yep.
sorry, no, Bill, you probably have questions.
No, go right ahead. Go right ahead, Kostas.
Well, people also have misled on this in one other way, because I fell for it too initially, where there was this article a few months ago, oh, state of New Hampshire gives SIG immunity from lawsuits. What that legislation in New Hampshire actually did was say you can't sue SIG for not having a manual safety or the trigger shoe. It didn't say you can't sue SIG if your gun spontaneously goes off, you know? So you can still sue for that. So people misunderstood. They thought New Hampshire was going after or protecting SIG from guns just going off by themselves, when really it was about the design of these guns. Because frankly, maybe there are safety concerns about P320 and its trigger being too light if it has no manual safety, in the same way that race guns or 2011s have very light triggers, you know, and I guess they do have manual safeties, but same idea, light trigger can be risky, I guess, but that's not really what the controversies have been. The controversies have been these videos we've all seen of guns apparently seeming to go off in holsters. And that isn't a light trigger thing. That's just, you know, something's causing it independent of the trigger. Anyway, I mean, I guess SIG would argue maybe some string gets in there or whatever else. I've seen their explanations. I don't. Well,
that's been part of the problem, isn't it? Is that SIG has, everyone's been looking for, as Tom put it, the sizzle. Right. Yeah. Everyone's been looking and said, and there's been a little bit of sizzle, but there's been a lot of fabricated sizzle. But then also SIG created some sizzle on their own with just really shitty messaging. Shitty messaging.
Undeniably. I just wonder, because I've seen those videos and I don't deny them. I'm like, yeah, nobody's touching that holster and that gun just went off. But then how come people can't take that gun and replicate it on that gun? Yeah. Why? Like, is this just a thing that is like winning the world's worst lottery, where it happens once every 10 million times and you can't really make it happen again? Like, but it is a inherent thing that's a risk. Like, I wish we could get answers, because I love my 320s. My favorite guns to shoot are my 320s, but at this point, I'm not carrying it because you never know. I'm not going to risk it, right?
Well, see, and therein lies part of the problem, though, is that we do need to figure this crap out, because any relationship you have with a firearm company, especially that who makes your everyday carry, you talk about a relationship built in trust.
Yeah.
Right? It's all built in trust. That's what the whole relationship is about, man. I trust that firearm to save my life and that of my loved ones if it's go time. Yeah. And there are people out there who are SIG fanboys, it's like they're Glock fanboys and all that, whatever. Everyone gets to be who they're going to be. And this really, we got to get to the bottom of this. And this is where I will be a little critical of other content creators in the sphere, without naming names, that it's kind of hard sometimes to get to the bottom of things when we're just, I don't know, just rage clicking, man. Yeah. Just rage clicking on the deal.
Yeah. But it works. That's why people do it. I mean, you know that. We all know that. That's the quiet part said out loud. Like people do it because it works.
Yeah, it does. It does. All right. Well, Tom Grieve, you get to pay. You think there's something up with this firearm, right? I mean, we don't know what, but don't you think there's just a little too much smoke for there not to be some fire somewhere?
I talked to a very nerdy gun engineer.
Might be the same one I talked to.
I don't know. This was a year or so ago now.
Did he call you or you call him?
No, I don't think this was the same guy. I don't think this is the same guy. But yeah, I talked to a very nerdy gun engineer and asked him. And you know, I've gone through armor courses. I know you have.
You know this everything. Stuff. Yeah.
I'm 0% an expert. Let's be clear. I am not trying to stake a flag on the expert hill here. But it's to say that I can follow the conversation, right? And he talked about how early SIGs, there were some parts that were poorly designed. Then, you know, there was kind of a voluntary recall and yada, yada, yada. So he still did not trust the design of the SIG. He said that they fixed it, but they didn't fix it all the way. And look, SIG's a huge corporation. The U.S. government is obviously went with them. I heard part of the reason was that SIG gave them the all-time cheapest deal ever.
Greatest deal
Uh,
ever. Yeah.
right, yeah. But look, I really want to believe the best. There's definitely some smoke here. There's things that just don't make sense, as Costas pointed out, and I don't feel like we have the answers to it. And I'm
Nope.
just going to follow it, like all of us, to the bottom, and we'll see where it goes.
Yeah. Okay. All right. Well, you want to do something a little more fun? Let's talk about this. Let's talk about how crappy everything can be. We're going to play a little game. Three of us are going to play a little game here. And this is the rules in America's most evil gun laws, okay? Is I want you to tell me what is currently the most evil type of gun law. It has to be one that's actually in existence somewhere. So if you come out like, well, the most evil gun law would be to, abolish the Second Amendment. Yeah, I get that, but that's not in play right now. So it's got to be a law that is actually in play. And then you're going to tell us what it is and why. Tom, you get to go first.
I'm going to say this. I'm going to say that the most evil gun law, and hear me out, it's actually AR-15 bans.
Okay, let's hear it out.
Why? Because the acceptance of a so-called assault weapon ban is predicated on swallowing the medicine that it's okay to ban certain highly dangerous firearms. When those are the exact sort of firearms you're going to be reaching for, if we're talking about what the Second Amendment exists for, which is tyranny number one, robberies number two, right? So if you get the public to swallow the medicine that so-called assault weapons bans are okay, that not only takes off America's most popular rifle and will do untold damage to the firearm industry, but more importantly, the long-term insidious damage is that it completely inverts the meaning of the Second Amendment. And from AR-15s, I mean, look, I don't know how they deal with handguns now that they've been blessed by the Supreme Court, but I've got no doubt that once you've bought the reasoning to banning AR-15s, handguns, like they're on the list, they're just lower.
They're uniquely dangerous.
Right,
Or something like that.
Right, all that kind of stuff.
Yeah.
Right. Well, it's like 72% of homicides are committed with a handgun, right? I mean, the arguments write themselves.
Yeah.
So
well, that's a good argument. Okay, that's a good argument. So because it would literally preclude us from having any possibility of defending ourselves from public violence, tyranny, the one that no one really ever wants to seem to talk about, but was a central component of why we ratified the Second Amendment to begin with.
That's where it starts. That's where it starts.
So, all right, that's a good answer. Kostas, what's yours?
There's so many to choose from.
I know there are. That's the problem.
But I take particular umbrage to the one of them we're suing over, which is Santa Clara's $2,000 in total expense to get a carry permit. I think that's evil, and I think it's the exact sort of Jim Crow style law. They know what they're doing, which is, they're upping these fees because they know $2,000, it's a lot of money, but it won't bother the wealthy Santa Clara residents. No problem, $2,000, okay, but it will bother a lot of the undesirables that they don't want to have carry permits. And by the way, when Santa Clara adopted this increase in fees, because they were already charging about $1,200 before, which was already insane.
Nothing's cheap in California. We know that.
More.
Nothing.
And California is expensive in general for a carry permit.
Yes.
But this is outrageous even for California. This is about 4 times the average and of the already expensive average, which is around $500 or $600. And at the when the Santa Clara County Board adopted this, the NAACP showed up and testified against it. And all they could say was, well, we'll keep track of this and see if it actually ends up disproportionately affecting minority communities. Like, come on, it is. Like, that's the point. Stop, don't bullshit, So
right.
So I think it's especially bad because gun bans, of course, are bad, but they've been doing that forever. This is bad because they got a ruling from the Supreme Court saying there's a general right to public carry, and they're like, okay, how can we maliciously undermine this? Let's charge a $2,000 poll tax on everyone trying to exercise this right. It's insane. And I hope we prevail in that lawsuit.
That's a good one. Well, you know what? I'm really happy is I was worried that two of us were going to double up on something. So we're actually going to come in with 3 different ones. My big bugaboo is any type of licensing that's required to even access the Second Amendment, pre-purchasing licensing, because I believe at that point we have converted a right to a privilege in which you have to get a hall pass or a permission slip to exercise. I know that right now they have so long as it use these objective criteria that you find in Bruin footnote 9, but we already see states that have evolved from that. And the mere conversion of a right to a privilege is the ultimate way of denying access to the Second Amendment in general. I think it's one of the most offensive things. It's like having to get a permission slip to go to church. It's like having to pass a class before you can qualify for a public defender. It's like, having to prove your worthiness at a live fire drill before you don't have to be, before you're free from unreasonable government searches and seizures. And so that to me is the most dangerous gun law in America.
Unfortunately, all right. It's a target-rich environment.
Yeah. Now listen, I told Tom I might throw in one heavy thinking one, and I'm going to do this because for those of you out there who aren't watching Tom Grieve, by the way, let's do this real quick because he's done a really good job of branding himself. So right there, you can find him. You can find him right there on YouTube at Attorney Tom Grieve, on X at Attorney Tom Grieve. That's really good branding, by the way, Tom, that you could just, everything's Attorney Tom Grieve. I guess his OnlyFans page is also at Attorney Tom Grieve also.
You said it, but I can't help notice that it's all shot in your studio. So
yeah, well,
CGI,
chill on that though. But no, this is the truth. This is the truth. I have gotten to know Tom on a personal level, just through circles we run around with. He's a great guy to hang out with. But Tom is a very Zen kind of guy. Tom's a very cerebral kind of guy. He's a deep thinker. He reads a lot of deep thinking stuff, and he and I have engaged in some really thoughtful conversations. Would you agree with that, Tom?
I would absolutely agree with that, and hopefully everyone knows
and I enjoy it
more than mutual as well. And for you too, Kostas, I've talked with you, I think at least a few times offline, and they've all been fantastic. So
we're gonna get away from all the gun law and stuff like that. Tom, I'm gonna ask a favor out of you. Kostas, as you know, an aspiring attorney with a very young family, and you and I have talked about all that work-life balance of trying to be a really good lawyer and yet be a really good husband and a really good dad and all of that. In 1 or 2 minutes, I want you to give him just a little advice about stuff you've learned. See, I told you this would be a thinker.
Okay. Yeah. Not what I was thinking you're going to be going for. The thing about law is that, as any attorney will tell you, and I know that the job is truly endless. You could spend 24 hours a day and still just scratch the surface. I mean, this is everything you ever heard about no painting or book or work of art is ever done. You just stop. And that's the way I feel about every video I'm doing. At some point you got to put the period at the end, file, save, print, and it is what it is. And the people who don't seem to be able to put up those walls and they just insist on sprinting the entire marathon, those are the people who, they're on like their fourth marriage and, all their kids hate them. They've got no relationship with much friends or family outside of court clerks, maybe some judges and bailiffs. And, right. I don't think that's what any of us would define as success. And I also think that when it comes to being as critical as someone like you are to the frontline fight for the Second Amendment, people who lead those kind of lifestyles, they're ultimately self-defeating because even if you're throwing yourself entirely into your work, eventually the work won't give back to you. Now, Second Amendment will to a very large degree, but not the same way that faith or family or something like that will. And eventually your work will suffer. So I would say you have to strike that balance, not only for yourself and of course your young family, but also for the 2A.
I appreciate that. No, that's great advice. And actually one of the things I'm grateful for SAF for, by the way, I love my former employer, Michelle and Associates. We still work with them, great firm. But about half my job there was stuff I frankly didn't care about. Like it wasn't the gun stuff. It was all the regular law firm stuff that let us do the gun stuff, because that stuff pays. But SAF, I am able to focus and it has helped, in that respect that, because I have a now almost 3-year-old daughter and it seems like she was born yesterday and it's already been 3 years. So time flies shockingly quickly. And, and so I definitely need to make that more of a priority. So, yeah.
Tom, that's great advice. I'm going to call you later tonight. I got to get some more. I got to get a pep talk from you too. No, I'm just kidding. But no, I appreciate it, man. You're the best. Am I going to get to see you in Vegas next month?
I will be seeing you. Am I going to see you, Kostas?
I'm going to my first SHOT Show next month. I'm very excited. So.
All right.
Oh,
drop me a line.
Actually, January 20th.
Kostas is going to pop his SHOT Show cherry. Oh, my goodness.
January 20th is interesting because that's going to be my first day at SHOT Show. But before that, I get to live tweet the Wolford oral argument that I'm helping Alan prepare for all on one day. So
that's right, because that's on the 20th.
Yeah, to the first day of SHOT Show.
So you're going to be in Vegas doing that?
Yeah, I'm going to go to a Starbucks or something that morning and live tweet it as I'm listening to the oral argument, and then I'll head to the show floor for the first time. So that'll be fun. I've heard I'm going to get very, very sick and very, very tired, but it'll be fun.
Tom, you're the best, man. Thanks so much for being here.
Tom.
Happy holidays to you and your family. I can't wait to see you next month. Thanks, brother. All right. I told you, man, he'd give you some good advice. Hey, I will give you a piece of advice, though. You do start doing your immuno boosters now, because no, I'm not joking. This is the truth. I don't ever get sick. Okay. I don't ever get sick. I had a house full of COVID people, 2 boys and my wife, all 3 of them sick as hell. Never got COVID. I never get the flu. Don't get flu shots, whatever. I've been sick twice in the last 2 years. When? Right after freaking SHOT Show.
Yeah,
so,
I mean, I would just wear a mask there, but then I'll never beat the California.
No.
Allegations.
Yeah, you won't fit in there. You won't fit in. All right, the last couple segments, and then I'm going to get you out of here. First one, let's get a little update. Our segment we call "What Are You Doing?" Which is going to kind of just let us know what is the Second Amendment Foundation up to. I know you guys are up to a million things. Why don't you give us a few highlights about some stuff, big stuff that's coming up this month?
Sure. So I'm currently simultaneously preparing 2 amicus briefs. Well, they're actually already drafted. I'm waiting on revisions, but I guess I can spoil it. I think I've mentioned it on Twitter. The first one is Gardner v. Maryland, which you've talked about, I believe. In fact,
yes.
I was referred to the case.
You guys got in on that one.
Yeah.
Yeah. Who got you turned on to that case?
You did. You did. Well,
thank you.
a third party forwarded me your video. And that's how I found it. Because I mean, even as someone who lives and breathes this stuff, other than Charles Nichols, I don't think anyone can keep track of every petition.
I don't know. You want to know how I found that case? Yeah. Is I go over to the Duke Law Center's Second Amendment tracker now and then, right? And I was just looking at all the cases, and I was doing a search on what's on a conference on a certain date, right?
Yeah.
And I'm like, Gardner? The hell's this Gardner case? I've never heard of this, and I just click. And then the minute you look at the petition, you're like, well, that doesn't look like a normal Supreme Court petition, and then you it's a pro. So you guys jumped in on that with her.
Well, we haven't yet. We're going to be filing an amicus brief soon. And my understanding is she has retained counsel now for the reply brief, which will help. High profile counsel. I won't reveal it because I'm not sure.
The case has got a good fact pattern to it.
Very good fact. So
it's got a really good fact pattern to it. Yeah.
What's interesting about her case, though, is that because there's a lot of pro se filings and they're usually a waste of time.
Total waste of time.
And what happened, though, somebody requested a response from one of the justices asked Maryland to respond, which could just be, again, this all might just be Justice Thomas making Maryland work for it, and it's a denial. Fine. But the fact that they requested a response made us decide to do an amicus brief just in case this is something they're considering, because as our brief will argue, it is a little ridiculous that, if you want to carry in every state in the country, currently you have to pay thousands and thousands of dollars to get all these non-resident permits from all these states. And Ms. Gardner, the reason her facts are good is because she was driving in her car, she got rammed, she defended herself. She has a Virginia CCW permit, just not a Maryland CCW permit.
Yep.
And they didn't charge her with any other crime besides carrying without a permit. So it's the perfect case. I hope
it is, because it would appear that her display of the firearm in defense of herself was lawful.
Yeah. Yeah.
It was just the fact that she had it in Maryland.
Yeah, they didn't charge her with any other like assault or anything like that. So it seems like their only beef was the carry permit. So we'll see what happens. I think.
Listen, send me that brief when you guys file it, because I want to do another video on it.
Thursday is when we will file it.
We're gonna make her famous. We're gonna make her famous.
I think it's gonna be. I hope it's not just Justice Thomas, and I hope this should be, as we argue in the brief, this should be a summary reversal. This is something that should be a per curiam, but we'll see. We'll see if there's any actual interest in that.
Yeah. Okay. All right. Anything else we need to know about? That's a good one.
We're also doing a brief the following week in the Williams case, which is another Third Circuit spontaneous en banc case. The second time they've done this, where they've just taken a case en banc like they did with the assault weapons case. This one concerns, I think it's actually 2 cases in one. There's also this case Bost, but it concerns somebody who had a DUI over 20 years ago. And the federal government continues to argue that that should keep him prohibited. So it's kind of like range, although a DUI, granted, is a worse crime than some minor
food stamp fraud.
Right,
yeah, food stamp fraud.
I don't want to.
Was it a singular DUI, or was it like a felony DUI because he had a bunch of them, or he injured someone in an accident?
I think no, he didn't injure anybody. I think he might have had 2. I forget if it was 1 or 2. Regardless, the last one was in 2004, and he hasn't done anything wrong since then. And so I don't want to make it sound like a DUI is okay. It's not. It's a very
no, it's not. They're dangerous.
We shouldn't imperil others, but it's clear that even then he wasn't dangerous with a firearm. He made a bad choice when it came to driving, maybe 2 bad choices, but it's been over 20 years. He's been fine since then. And so we think that's a great example of a case that should be subject to rights restoration. And we'll see what happens. The Third Circuit took it en banc, and they asked a very specific question presented, which is, can we use evidence outside of the underlying conviction when it comes to deciding these sorts of cases?
Yes. I saw that.
And I think that's more about the partner case, not Williams, because Williams doesn't have the government.
There's not a lot, right? There's not a lot to it.
Yeah, but the other guy apparently has a much more sordid record and has done other stuff, which is
he's more of a Hamani Rahimi kind of guy.
Right. So I think maybe the Third Circuit took these together to kind of do like good example, bad example. You can give somebody like Williams' rights back, but maybe not this other guy. We'll see what they say.
Well, that'd be nice if they took that Harris case and attached that up with Hamani, so they could sit there and go, Hamani, disarm. Harris, come on, no way.
Harris, unfortunately, is an example of the Third Circuit getting it wrong. So we'll see. We'll see what happens.
Exactly.
Today, the government, the feds filed a quick response in Harris and basically said, we're not going to respond further. We just think this should be GVR'd after Hamani. And Supreme Court, let us know if you want a further response. So we'll see what happens. Okay. Yeah.
Our last segment, the craziest shit I read all month. We all read crazy stuff each month. Do you remember what the craziest thing was you read this past month?
Mine isn't my example, and it's funny because I spend so much time on Twitter rebutting crazy things people say, and then when you send me the thing to think about, I can never think of any, even though I've been doing it all month.
You got to go back on your X account and be like, I have to tear into.
But I'm not going to use a legal example this time. I'm going to use
that's fine. That's fine.
Something I talked about yesterday, which is an article from the Wall Street Journal. There seems to be a writer there, Mr. Mermont, who has a real axe to grind with carry rights, because this is his 3rd article focusing on carry. He did one about self-defense insurance, which, as you know, only protects you if you're legally defending yourself.
Yes.
And he did one on kind of about stand your ground last month, which I rebutted. And yesterday or this weekend, he ran an article the Wall Street Journal did about people with carry permits accidentally shooting bystanders. And the article gives 4 examples. It gives 4 examples. One was in Massachusetts, another in California, another in Ohio. I forget what the last one was. And these are cases where the person's legally defending themselves. All parties agree they were legally defending themselves against an attack, but a stray bullet hit a bystander.
Oh, they missed the target.
Yeah. And that's unfortunate.
Cops do that too, by the way.
Sorry?
Cops do that too, by the way.
Yeah, and that's one of the points I was about to make. So
unfortunate, but it's true.
The article made it sound like this is some super common thing that happens, even though it only gave 4 examples and no other data. And then it quoted some gun control groups as saying this is because of the rise of permitless carry and also shall issue licensing and stand your ground laws. None of those are applicable. Well, shall issue is, but permitless carry and stand your ground are not in Massachusetts. The article, the first example it used was in Massachusetts. Right. But the bigger point, was I pointed to data showing actually these homicides, these accidental homicides involving a gun, have gone down by 100 in the last 5 years. 100 a year, and that includes all accidents, by the way, not just stray bullets hitting bystanders. And secondly, cops do this way more often. And unlike a police officer, this gentleman in Massachusetts that the Massachusetts Supreme Judicial Court, they tried him for murder. And the Supreme Judicial Court said, no, like it's unfortunate he hit somebody, an innocent bystander, but through transferred intent, this wasn't his fault. Like he was defending himself legally. And this is actually the fault of the criminal that perpetrated the situation. And now he's being sued civilly. So they can still sue you for civil damages. You know who can't be sued for civil damages? Police officers. They have qualified immunity. And
the ones that actually usually are better trained, in all likelihood, better trained than the gentleman in Massachusetts that had to do this.
Yeah, I mean,
a little bit more prepared for a situation like that than the gentleman in Massachusetts.
That's what they say. But LA, I mean, I found this article that said LAPD alone, this is just not nationwide, had shot 21 people across a decade, innocent bystanders. That's just one police department. And I'm not saying I even blame them. These are crazy situations.
Oh, yeah, no. When it's go time, you don't, crazy stuff starts happening.
Journal picking on, 4 people with a CCW permit and implying without data that this is somehow much more common than it is. So I thoroughly rebutted this. I also sent my rebuttal to the editors, but don't count on them ever doing anything with that. Anyway,
I won't hold my breath. The dumbest thing I read this month actually came from a letter from the IACP that Everytown and Giffords was all pumping up because they don't want House Resolution 38, National Concealed Carry Reciprocity, where they wrote in there that the legislation would override these tailored arrangements and strip states of their ability to set and enforce their own standards for concealed carry, which, as you know, in some states, the standards for concealed carry is there is no concealed carry whatsoever. So,
they try and effectively ban it. Yeah, totally.
Yeah. So, anyways, all right. Listen, our next Behind Enemy Lines, Volume 4, is going to be Monday, January 12th. We're going to get Kostas all ready for his first ever SHOT Show. Do you know where you're staying down there yet?
I'm staying with family, actually, saving.
You got family down there?
Yeah, I've got a couple family members down there.
That's good. Good for you. Yeah. Good for you. All right. Well, I'm taking you out for dinner, man. We're gonna if you can get away from family one night. All right. Listen. Anything else you want to say before we call it a night here?
No, I think we covered anything I could. If you guys stay after, I'll rant about Rhode for another 30 minutes.
Listen, I may next month, I may just start with that. And like I say, I'm going to go make myself a sandwich and stuff, and I'll come back in about 30 minutes. That was that was worth the price of admission.
Well, now you have your clip for Twitter and all that.
Oh, that's a good one. That is a good one. I appreciate it. Hey, happy holidays to you and your family, brother.
Same to you. If we don't talk,
Thanks, everyone.
Happy New Year. Have a good one, guys.
Yeah, take care.